What happens when a whistleblower has inside information of government fraud? It can be, for example, an accountant who sees that there are false billings that are being submitted. It could be maybe someone who works at a vendor who provides services and knows that the services being provided aren't really what the government's paying for. So when an insider has that kind of information, the key is that they be the first ones to actually file a complaint. And the statute has some very specific provisions on how that has to happen. First, the whistleblower has to do what's called a presentment to the Department of Justice, and that's usually done at both the local U.S. Attorney's Office and the United States Department of Justice. Now, the way the Department of Justice works, there's Main Justice up in Washington, and that's the federal agency that basically controls this particular area of the statute. It's within their umbrella is the FBI, the IRS, Customs, DEA. But the U.S. Department of Justice also has the U.S. Attorney's offices under their purview. Now, the U.S. attorneys, every district in the country has a U.S. attorney. It could be, for example, here in Florida where our office is. We have 3 districts. We have the northern, the middle, and the southern. And each one of those districts has a U.S. attorney. Now, the U.S. attorney is the lead prosecutor. They're appointed by the President of the United States. And under the U.S. attorney, there are assistant U.S. attorneys who are the prosecutors, the folks who actually are on the line prosecuting federal crimes and prosecuting the civil cases involving the False Claims Act. And so when a whistleblower has evidence of a false claim, first the statute says that they have to present that claim. They have to basically prepare a package that contains a detailed list of the evidence that they have, any documents they've prepared, as much information as they can possibly put together within reason. They can't, of course, collect anything illegally. But that inside information has to be put together in a package and then taken and presented to both the U.S. Attorney's Office, which is the local office, and also to the Department of Justice up in Washington. And once that's done, then the relator, or in the relator is the technical term for the whistleblower, then the whistleblower has to file a complaint under the False Claims Act. Now, a complaint is a lawsuit, and that has to be filed in the local district court or wherever the whistleblower has evidence of the fraud. And it has to be filed very specifically under seal. And that's a specific provision dealing with the kind of lawsuit that's not public. And there's a way to do it, and you have to make sure it's done the right way because the information can't be made public until such time as the government has made a decision whether to intervene or get involved and prosecute the case themselves or not. So again, the process is present the case to the U.S. Attorney's Office and to the Department of Justice, and then file the complaint under seal in the local jurisdiction. Now, it's also very, very critical that all of this be kept in the strictest of confidences, because at the end of the day, the whistleblower or the relator is going to, hopefully, if the government does not intervene, stand in the shoes of the government to prosecute the case on behalf of the government. So presentment, case presented to the U.S. Attorney's Office and to the DOJ, then filing of the complaint under seal, and then the government gets time to basically consider whether or not to do what they call is to intervene in the case. And an intervention is basically when the government makes a decision to take the case on themselves. If the government then decides, hey, you know what, we want to get involved in this, we like this, we feel that the evidence is good, we're going to prosecute this ourselves, the whistleblower then basically stands on the sidelines and acts as a partner with the government to assist the government in moving forward with the case. If that happens and the government gets a recovery, then the whistleblower gets a percentage of the government's ultimate recovery in the way of a reward. If, however, the government decides not to intervene, they decide, you know what, for whatever reason, we don't think there's enough evidence, we don't like the case, we don't have the resources, whatever it may be, the Department of Justice can make that decision to not intervene. At that point, then the complaint becomes unsealed, and then the whistleblower and their lawyer can make the decision on whether or not to proceed by themselves without the assistance of the Department of Justice to prosecute the claim. And so under either one of those scenarios, it's really a partnership between the Department of Justice and the whistleblower to prosecute this claim on behalf of the United States. And if there's a recovery, depending upon the degree and the nature of the whistleblower's cooperation, at that point the government and hopefully the court will award the whistleblower a percentage of the recovery. And that's basically how the False Claims Act and the whistleblower statute works.